Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios East and West and transmitting across the internet. This is episode 66 of Registry Matters. Happy Saturday, Larry. How are you?
Doing fantastic.
Oh my God, you're fantastic. What's wrong?
Well, I'm having a great time.
Because you're usually kind of an old curmudgeon and you're like, well, I guess I'm okay. I'm still here.
The legislature's in full swing, so it's exciting. Politics
Absolutely.
is my life, you know. Don't you people understand that?
I do know that about you, that this is pretty much all you live for. And like if you step back to the 30,000 foot level, all the stuff that's going on in with the politics at the federal level right now has got to be just like you're running around a candy store with free reign at the moment.
So it's the best time to be alive.
I can only imagine. And you were post Spawn when Nixon was around, right?
Oh, Nixon! I go back to the Lincoln administration.
Now remind me of one thing though. We had talked about this earlier, and I was going to I'm going to bring that up, and I was going to, it won't be about faucets and it won't be about cars. What was the thing that I was going to ask you about?
I don't remember.
Me neither. I think you're just saying that so you don't want me picking on you. Well, we have a new patron, Larry.
We do.
We do. We have a patron named Robert, and he's at the supported level, so he's a rich MF. If you need anything in your locker box, go to Robert. Robert can hook you up with soups or, chili packets or anything like that.
What is the supporter level? Supported level? I mean, not supporter, but supported level.
It is. I think it's that's $15.
Yeah, we have the new level, where you put the gross of your paycheck. Then we have the net of your paycheck.
This isn't that level. So, that's the advised level.
But so far, we haven't had any takers at either of those levels.
I can't even fathom why that is a thing. Like why nobody has taken us up on it. We should just have people lining up at the door and they can't get in.
I don't see a problem with it myself.
I do want to take a moment and just say to all of the patrons, thank you so very much. It is incredibly appreciated. And then to all of our listeners too. Yeah, we like you too.
We have our favorites that we really like, and then we like everybody though. But
yes, that is correct. Well, let's get things started going.
Let me make a personal announcement to one of our listeners, to Charles.
Charles in New York, okay.
Charles in New York. We're looking forward to having Charles at the conference. He won from NARSOL on a NARSOL in Action conference call. He won.
I remember that.
And he's indicated he's going to attend this year, and we're looking forward to having him. And I have no doubt that we'll be able to find. He has visual impairments, but I have no doubt we'll be able to find a chaperone that'll help him navigate around the hotel. I believe it's like a 12-story hotel, 12, 13 stories, but we'll be able to help him get around the
probably.
hotel. I have no doubt that we would be able to find a chaperone, a person to be of assistance to him. We'll find someone who will help Charles get around, and look forward to having him there. And then I sent him an email telling him to just go ahead and call the hotel, book his reservation. And anybody who books a reservation, just to remind you, if you book your hotel rooms, they don't charge you. They have a credit card or a debit card number, but it holds the reservation. But there's no any assessment for the lodging until you check out. And unlike us at NARSOL, we're gonna get your registration money before you check out, because probably people wouldn't pay if you collect it on the way out.
Yeah. Hey, do you know? Okay, since you're from the Lincoln administration, do you remember a Little Rascals episode where they said "pay as you leave"?
I don't remember that. No.
They did one of their little plays, and I don't remember the whole storyline, but anyway, so they would always do their little plays and Alfalfa and Darla and whatever. And somehow I remember the title of the episode was "You Can Pay as You Leave." So they did something in the program where they got everybody in there, and they did something that they were just so anxious to drop off their nickels and quarters as they went out the door.
But I can still I can still remember at least one cabinet member from the Lincoln administration, Secretary of War, Edwin Stanton.
Were you at his confirmation hearing?
I was when the assassination took place at Ford's Theater. Secretary Stanton put out orders in terms of how to deal with the situation, and I was on his strategy team to go out and round up the assassin.
You were on the strategy team. All right then. Well, we received an email message from Carl.
That's why I said that my favorite country singer that died, he was only 91. But
yes.
If you put that in context with my age, he was quite a youngster.
Yes, that's a young whippersnapper from your context, right?
That's correct.
Well, Carl says, I've been listening to your show for a short time. Very good job. I'm in Texas, and there are two issues I would like to discuss. One is, would you say it is true that the government gets away with some of the bad laws because most of the people on the registry are low income? I was convicted in 1998 and went to prison for 5 years, did it day for day. Before I went in, I was low risk. When I came out, I was high risk. In 2010, I went back to prison for failure to register. I did all but 5 months. When I got out, I was low risk again. By the time I got off parole, I was back to high risk. How can they keep changing me like that? All I've done is try to find a job and a place to live. Anyway, keep up the great work, and thanks. Well, thank you, Carl. Larry, tell us what you think about Carl's question.
I don't know if I'm going to be qualified to answer that entire question. The system does feed on poor people. That's all across the board, though. It runs the gamut from traffic tickets to minor misdemeanors it's a cash cow, and so I would agree that first part of his question that they do get away with a lot of stuff from poor people. And poor Bernie Sanders said a week or so ago that poor folks don't vote. Do you remember that? And he's taken a lot of heat for saying that he said poor people don't vote. He says poor.
You're not picking on his New England accent, are you?
And the reality is that for a variety of reasons, some of them are logistical and barriers are in place of voting. If you don't have transportation, reliable transportation, that can be a barrier. If you don't have identification in the states that's current, you can have your identification lapse for a variety of reasons. You could be imprisoned. I think you guys can relate to people whose ID expires when you're in prison, and then you end up coming out. You end up having a lot of cost associated with trying to get the documentation, because suddenly, even though it's your picture on there, you're not the same person anymore. And I've never figured.
I had to redo my whole driver's test.
Absolutely.
I actually had to do the motor vehicle test. That's crazy.
I have never understood how, if identification is supposed to, and we're getting off topic from what his question, we're going to get back to it in a second, but I've never understood how, if the photograph is you and it expired yesterday, if it expired February 28th, 2 days ago, how you magically become someone else on March 1st or 2nd. If you look at the picture, as long as that was issued by a governmental entity and you're reasonably sure that's not a fraudulent ID, why is it no longer acceptable to identify you because it's not currently enforced, but it's still you. It shows you. It has your name on it. And that's one of the things I want to change in our state law here, which I'm not going to be able to get it done this year. But when you go in a grocery store here, you will get carded even if you're my age, because it says that a licensed alcohol distributor shall not consummate a sale to a person who cannot produce a valid ID. The retailer takes that to mean that you shall impose that requirement on everyone. Well, that's not what it says. It says to a person who cannot produce. But I believe that leaves open the opportunity for you not to ask the person if you don't believe an ID is necessary. If they look like they're 80 years old and the legal age is 21, they could have produced it had you wanted it, but you didn't deem it necessary. But if you can't produce an ID here, you have to. And then if the ID is expired, they say, "Well, I can't sell it to you." Well, it's not a valid ID. The law says valid ID. Well, do I magically become someone else with the ID? But back to his point,
you are no longer valid the day after. You are no longer a valid human.
There can be, for poor people not voting, there can be a number of barriers that ordinary folks that don't have those challenges would not understand. But the politicians understand it because they do great analyses of who votes and where their votes come from and where their votes don't come from. they look at precinct by precinct, and they figure out of the voters the demographics of where they're going to get votes from to win the requisite number for their particular race. So I would say that he's correct. Carl's correct that has a significant weighting on what gets done to people, because people who don't push back are more likely to have things done to them. Have you noticed how effective the American Association for Retired Persons are, the AARP?
They are very, very prolific and very active. Yes.
You've noticed the National Rifle Association?
Yes, they are also they're probably the biggest lobby. Is that fair?
I think AARP is bigger, but they're both very powerful groups, and those people will turn out and vote. If you were to poll either of those memberships, you'll see that their turnout is above average. If a person's a member of the AARP, they're very likely to vote in numbers that are greater than the population's turnout. You do the same thing with NRA card carrying NRA members. They're going to vote in numbers. So when you're dealing with politics, it's all about getting votes. I mean, I know it breaks people's heart for me to tell you that, but our system requires you to have the majority of the votes to get an office. So when you're out trying to get votes, that's what you're in for. It's a contest to get more votes than your opponent. I mean, it's really not that complicated. And,
right.
And the other part of his question, I don't know that I'm qualified to answer because I didn't study on the Texas risk system in terms of how they do it. Probably the good thing would be for Carl to speak to an attorney who actually does practice in Texas, and there are a number of them. And being such a large state, there are a number of people who try to navigate that process. But I would say, just off the cuff, it's one of those fallacies of a risk-based system. People that don't understand how flawed those systems are, and I would be guessing that there's probably some arbitrary and capriciousness in this, and he's probably not able to exercise whatever remedies there might be to challenge these ratings, and he ends up getting stuck with a higher rating. But I don't know enough to feel qualified to say how it keeps changing and what his recourse is.
One thing I'll just add is just I think it was even this morning, I was listening to a podcast on a program called Today Explained, and they said the title of it is called "Your Money is Under Arrest," and they talked about how poor people just end up in this virtuous cycle of the police target you. You carry cash because you don't have a bank account, and they can just they can arrest your money, even though there's no crime, but you're carrying around $1,000 and well, you must be doing something illegal if you've got $1,000 cash on you.
You have to be. I mean,
of course,
what right-minded person would be carrying that kind of cash around? So you have to be up to no good.
Absolutely. So as part of your first statement in there about the making bad laws because people on the registry are low income, it is not just people on the registry are low income. People that are low income face this sort of hurdle. Anyway, so there's a link in the show notes for that.
I see that, and that's I was telling Carl that yes, it does bear into the decision making. When constituencies come to you wanting laws, there's an analysis done in terms of where the pushback's going to be, and the stronger the pushback, the more likely you are not to succeed in getting bad laws passed. But on the registry stuff, there's just not a lot of pushback. The registry community doesn't have a lot of allies, and the registrants themselves are not very well organized, and it's very challenging to try to push back with the limited resources that are out there pushing back.
And then we received another email message that I don't even think I should mention the person's name. But talking about your position on the separation of powers, do you want to cover this one?
I don't think I've had enough time to fully digest the email. It was quite lengthy. If I read the right one, isn't that the long one you sent me in the middle of the afternoon?
Yeah, I mean, yeah, it is. It is. So, do you want to not do it? I wanted to give you a chance to defend your position because I feel that the position that was stated about how you think of things is wrong. I actually started going through and answering the email message, but I figured we would just cover it on the podcast. That you are either in favor or not in favor of judicial activism. And the way that I was trying to explain it back is that people that are on the left, when judges go and make a decision that impacts, then the people on the right go, hey, well, that's judicial activism. We don't want that. We have separation of powers. And it happens on the other side. So when the people on the right, when the justices on the right make some sort of decision, the people on the left go after them too. And depending on your bent on that subject, you either do or you don't want the judges to intervene. we have the separation of powers and all this. That's what he was going through and talking about unconstitutional laws. And you have said repeatedly, laws are assumed to be constitutional when they are put in place. And until we go back and challenge them, they are constitutional. And then we even did a whole episode that was called The Justices Are Not Roving Tribunals. So they're not actually running around trying to find laws that would be unconstitutional. They just are there when we bring the cases to them, and then they judge on them when it happens.
Well, I've got the email message now, and it's not as long as I thought it was. I must have got it confused. But he says SCOTUS appropriately struck down that law as unconstitutional. I guess he's talking about Brown versus Board of Education.
Yeah.
Even though it was properly passed. Well, I'll try to clarify my position. I have not really, I don't think, played my hand completely in terms of judicial activism. I have played devil's advocate about this.
Right.
What I try to do on the program is to get people to take an inward look at themselves, because I realize I'm talking largely to a conservative audience, and they are the ones who generally rant and rail against judicial activism, that they don't want any legislating from the bench. And so when I make the comments I make here without playing my own position, without revealing my own position, like on the Nebraska case we've talked about repeatedly, the majority of our listeners are going to fall into the conservative camp who believes that they think they believe in strict interpretation. Right. And I'm saying, okay, this is what you got. You should be happy with it. This is exactly what you got with the decision that the Nebraska Supreme Court rendered that's going to potentially, when the stay is finally lifted, there's another stay in place according to Hank now, but eventually that's going to be lifted because that's what the state gets to do. They get to decide how to interpret their own state law if there's not a federal constitutional violation. And so I'm really being a devil's advocate. And then I contrasted that with the federal district court, Judge Koff, who took a more interventionist approach, trying to read between the lines and figure out what a good public policy is. He looked at it differently from a policy perspective, that since Nebraska doesn't register in-state convicted juveniles, that it stands to reason they wouldn't want to register out of state. But they didn't say that.
Right.
But I'm really trying to do a lot of devil's advocate here. A lot of us tend to be very inconsistent in our views. When it's pointed out to us, I got an email from a constituent of the senators who she claims to be a fiscal conservative, and she claims to be something that she's not. She's asked for a 6% raise, cost of living raise, for people who are under our public employees retirement system. She's a retired public employee. She wants a 6% instant raise. She wants to remove the COLA cap, the cost of living allowance cap, which they have, trying to save the PARA system, the public employees retirement system, because long term it has more obligations than it has anticipated revenue. And she's saying don't raise any taxes because there's some tax enhanced proposals here in the state legislature pending right now. And then she's saying that she wants more funding for the university athletics, which the athletic department is in free fall because the teams are so unsuccessful that attendance has dried up and sponsorship is down. She's asking for all this government spending, and then she's saying that she's a fiscal conservative and wants no taxes. What I do is I call people out on that, and I ask them, how can you have it both ways? How can you
and not that you're necessarily picking a side, but if you're trying to say, hey, we need to get these raises, well, how are you going to pay for it? Pick one side or the other. You can't straddle the fence and have people get more money without then also increasing the revenue side to support it.
Absolutely.
Right.
There's a board member of another national organization that advocates. She had that discussion. I think they get 3 public retirement checks, and she said, I'm entitled to these checks. We worked for it. We would have gotten them in the private sector. I said, well, maybe you would have, maybe you wouldn't have, depending on where you worked in the private sector. That's not the conversation I'm having with you. The conversation I'm having with you is, how can you constantly suppress tax revenue and want the benefit that you have your handout for? Because someone has to pay the taxes for that, unless you're the federal government, which they just run huge deficit year after year, but states have to balance their budgets. And so I'm attempting to get people to do thinking and to take a look at themselves and say, am I being inconsistent? And I'll occasionally confess my inconsistency. I've done that on the podcast about state preemption of local control. Right. I profess to be a big believer in state preemption because, like in the matter of registry, residency restrictions, proximity restrictions at local communities, we've prohibited those through state preemption. But magically, I believe in cities being able to have a higher minimum wage because I'm for a minimum wage increase, and we can't seem to get it to federal level. And we've had trouble getting it to state level because our previous governor has vetoed every increase regardless of how small. So magically, I do a flip-flop on that. Well, that's me being an inconsistent person. I don't mind you calling me out my inconsistency also, but I don't think I'm being inconsistent on separation of powers because I really haven't been clear on where I stand.
Yeah, that's kind of how I felt. I felt that I feel that you are constantly you are in a position on a very regular basis where you're talking to constituents or you're talking to the representatives, senators, congressmen, and you have to be able to present these arguments to them in a way that they can digest it. But the final sentence of the email says, "I would like to hear Larry explain why he thinks legislature seems to have more power than the other branches." And I totally don't think that you represent it this way, but it may have come across this way.
Well, they have a different set of powers. They through our evolution of our democratic process, they have a different set of powers than the other branches. The legislatures laws have to be enacted through a legislative process. So like when people say, well, Obama signed international maintenance law, well, he did sign it, but it was Boehner and the crowd that passed it. Obama could never have enacted it without the legislative process. We can get into another philosophical debate about overreaching executive orders because some of those may or may not be constitutional. But the legislature has a different set of powers. The courts have a set of powers that are defined in terms of the administration of justice and in terms of reviewing legislative actions that are challenged. The legislature has enormous power because they are presumed to enact constitutional laws. The presumption goes in their favor. I don't make that rule. I'm just relaying what the judicial system has decided, to defer to the legislature on every enactment and presume it's constitutional until a challenging party presents clear and convincing evidence that it is not. It's not Larry's rule. That's the court's rules. You can look at Broderick versus Oklahoma, where the U.S. Supreme Court clearly articulates that standard, and so that legislature has a lot of power. If people gain access to a majority of those seats, and they're willing to push the envelope and enact legislation that may not be constitutional, and well, until the court is presented with a challenge, those laws can operate with impunity because they're presumed constitutional. Now, interestingly enough, in our state, we have a debate right now about sheriffs are saying that they're not going to enforce some expanded background checks on guns. They're saying that they're not going to enforce that. Well, the sheriffs are wrong for one simple reason. The law, if it is passed, it hasn't passed, but if it is passed, It is presumed constitutional. Now, the sheriffs can file a lawsuit right away if they want to and seek an injunction, and they can say, we can't enforce this. We don't believe it's constitutional. But until you get that injunction, or until a court says it's not constitutional, your job is to enforce it. Now, you may give it a low priority within your budget, but your job is to enforce that law. And it's not your determination. You're wearing a badge and a gun. You are not wearing a robe, and you do not hold a judicial office. It's not for you to determine what's constitutional.
All right, then. Got 8,000 articles to cover. Are you ready?
Yeah, let's do it.
All right. This first one is a struggle to understand up front. But so NewYorkCourts.gov is the article. And it says the synopsis, I guess, would be a guy was convicted of a crime like attempted burglary in the second degree. And I think there was a sexual component back in the 90s. And then gets a later conviction and sentenced to 12 years. And so in 2016, if I have this right, he commits another crime that's unrelated. But then when he gets out, because he had a sex crime way back in the day, then they say that, hey, you're under sex offender supervision and you have all these other restrictions that go along with it. Did I do halfway okay?
You did a fine job. That's exactly that. That's what it's about.
And this is a problem. Why?
The problem. Well, it's a problem because the New York courts are kind of organized strangely, and I don't fully understand it, but I can tell you that the trial court upheld the Department of Corrections, or whatever they called their probation supervision. They put that condition on the individual. He was not being released from prison for a sexual offense conviction. He was being released from prison for another type of conviction. And they said, well, according to the law, it says if we're releasing a level 3, and New York has a risk-based system, that we have to put all these restrictions on. You are a level 3, aren't you? Well, yes. Well, that's what the law says, yes. Well, then we're doing our job, yes. And he said, well, no, because I'm not being released for a sex offense. They said, well, don't tell us your problems. You're a level 3 offender, and we're releasing you from prison, and you will comply with these conditions or we'll lock you up. And he challenged that, and the highest court has said, or at least the highest court that's reviewed it so far, has said they agree with him. Now, the trial level court upheld the department. The trial level court appears to be called the Supreme Court, but the Supreme Court is not the Supreme Court in terms of what we think of. It looks like the highest court in New York is the Court of Appeals, but the trial level court said corrections has it right, the supervising authorities have it right, and the appellate review court said, nope, you don't have it right. He does not qualify, and we read black letter differently. We read it that that these conditions apply if he's been released from prison for a sexual offense. The reason why this is important is because states all over the country take that position. Someone will have an older sex offense, and they may have had a sex offense that even doesn't encompass registration because it was so old. I know it happens in my state, and they'll pick up something a different type of charge, and they'll put them under sex offender supervision. Now they don't require them to register because they're not within the zone of the registry law, but they'll put them under sex offender supervision, which is all the conditions of curfew, polygraph, treatment, and all the restrictions around being. Well, you said, well, my sex offense was in 1987. They said, well, don't tell us your problems. You have a special need because you committed a sex offense 30 years ago. But I'm being released for a burglary. Don't tell us your problems. Well, what I like about this case is I'm going to try to use it. It's going to be in the back of my mind now, where a Supreme Court, state highest tribunal has said, I believe this came from the highest tribunal, said you can't do it that way. You must be releasing the person for a sex offense to impose this type of restrictions on him. So too bad, so sad. You can't do it.
Is this a function of just like the left hand not knowing what the right hand is doing? Is that how does something like this get fixed, or is it something even to be fixed?
Oh, it's the left hand knows exactly what the right hand's doing. They're doing this because they're taking a hard-nosed attitude of that we're not going to take any chances. Nobody wants the camera coming in to saying, now wait a minute, let me get this straight. You know the guy has proclivities to be a sexual offender, and you released him from prison, and all you did was put him on standard probation supervision. Have I got that correct? Well, yes, you got it correct. Well, why didn't you put him under more stringent? You know his history. Why didn't you require? Well, because he was not being released for a sex offense. Well, that doesn't play very well in the public. So they know exactly what they're doing, but they're doing it to make sure that they are that they're not going to have this blow up in their face. So
just to put the screws on as many people as they possibly can.
Well, they're doing it because they can, and then they have been able to do it until this guy said, "No, you can't do it to me."
Until you're told to stop.
The criminal court structure, the way it shows on my diagram here, the Court of Appeals is the highest court, and then they have appellate divisions of the Supreme Court, and then they have the trial level courts, which are consisting of Supreme Courts, county courts, district courts, and New York City. I assume that's what the NYC means, criminal court. So that appears to be the structure of the courts. So this decision here is from looks like the Court of Appeals.
Okay.
So we need
right,
a New Yorker. We need a New Yorker to come on here and help us understand this crazy organization of their courts.
All right, then. Well, since we're up there in the sort of like the Northeast, let's move on up to Maine. Do you remember roughly around October where we played the little clip of the people marching around the guy's house chanting something about "We don't want you living in our neighborhood"?
Oh yeah. I remember that. Was that in Rhode Island?
It was. It is up there in Rhode Island, and it's up in Providence. And the article is police monitoring of sex offender's home cost nearly $103,000. They had round the clock deputies guarding the guy's house from people doing all kinds of, vandalism, whatever they're going to do. And they finally decided to shut down the detail, and they ended the detail on February 15th. And then on February 16th, somebody threw a brick, threw a piece of concrete through the guy's window.
What's the problem with that?
Yeah, I mean, I guess if you were like sitting there watching TV when the concrete comes through your window, that might be bad for your skull.
Well, I've actually had one of those come through, and it's very discombobulating. It had nothing to do with registry. Anything. It was when I was in property management about 30 years ago. We had this mentally challenged guy, and the owner had told him he would pay him $5 an hour to pick up trash and just to keep track. That was an outside arrangement he had made because he was friends with a guy. He said, just let me know your hours. Well, the owner had told him to ask me for the money because he was not in the office. He said, just go ask Larry for the money. And I didn't know anything about it. So he comes over my door and asks me for like $25 for a cleanup he had done. And I told him I didn't know anything about it. And he got so frustrated, he threw a brick through my window. And it's very discombobulating when the projectile comes through your window. I can
totally imagine.
Yes, it is.
Hang on. I want to take a tiny little detour just for a moment. So there's some conversation in the chat with the people that are listening in. And I erroneously said Maine, but it was actually Rhode Island. Can you tell me how long would it take you to drive from one side of your state to the other?
Well, it's pretty long drive if you're going north to south. It's a pretty long. When I drive just
6 hours,
probably, but 5 hours for sure. I know when I drive to Las Cruces, it takes me between 3.5 to 4, and we're in the central part of the states, and Las Cruces is the very southern part of the state. So it's you've got a ways to go before you get out of the state if you're going north from here. So it would be 5.5, 6 hours.
And the reason why I ask you this is because I know you have a big state. And if you were up in Maine, Rhode Island, Vermont, whatever, you could drive 5 hours and you could make it halfway down the East Coast if you did that. Those states are so tiny up there, and I'm getting criticism for saying it was Maine instead of Rhode Island. So anyway,
well, Maine is much larger than Rhode Island. Rhode Island is a tiny state. I mean, you can't kick a football across it, but it is tiny in landmass. I think it's the smallest state.
It is.
Yeah.
It is. You know what I think I would have liked when I was 13 years old?
What would that be?
I would like a hot teacher to want to do the nasty with me and goober gobble with me when I was 13. What do you think?
You would have been thinking about those kind of things. You were 13. I don't think I was thinking that kind of stuff. Were you
Probably not. No, actually, because when I was 13, I had a bar mitzvah, and my parents hired a belly dancer, and I was petrified. I was sitting in a chair, and there's this woman shaking all of her junk. I was confused. I was scared to death. But this story is from Arizona Central, AZ Central, and it says the teacher Brittany Zamora had sex with a boy in classroom, and I know that this part is not true, but it says classroom while other student watched. The student wasn't watching them. The student was keeping a lookout. But there's this 27-year-old woman that's trying to hook up with the 13-year-olds. What is really interesting is if you go search over on Twitter for people talking about this, somebody brought up an interesting point that when they describe this, they say that the female teacher was trying to have sex with the male student. If you flip that equation around, it is not going to say having sex. It's going to say the male teacher was trying to rape, statutory rape, whatever, something along those lines with the female student, something like that. But this is good times.
The reaction would be largely different, with even though it shouldn't necessarily be different. It's just the reality of our society. When boys are growing up, the introduction at a young age to sex has been considered a good thing, and it makes a man out of them, quote. And the introduction, I can't, in my life, I can't remember anybody ever saying that an older guy introducing a teenage girl to sex has ever made a woman out of her. I don't recall ever hearing that.
Absolutely right.
It's one of those biases. that we just live with. It's one of those things about clothing. A woman can go in the store and buy anything that's sold and put it on, and not a thing happen. No comments will be made to speak of. You let a man go in the woman's department and start buying things and putting them on and find out what happens. Explain that one to me. Why is that double standard?
I don't know. I mean, we talked about we this comes up big time during the presidential debate of what does the woman wear versus like the guy's wearing a red or blue tie. No one gives a shit what the guy's wearing, but if the woman's wearing too red or too white or hair is not right or makeup's not right, it is ridiculously a double standard.
Absolutely. I was going to go there next. There's a double standard when it comes to reporting. We had a longtime general manager of KOAT 7 retire in the last few months, and she at one time was a reporter on air talent before she was in management. But she said when she was in her young days that people would call the station and she wanted to talk about news when they would always tell her something about how she could make herself look better on the air. Now, how often does a male anchor get that kind of phone call? Well, what I want to talk to you today about is that tie. If you'd have had just a little bit wider tie, and if you'd had a little bit tighter around your neck, you'd have looked a whole lot. I mean, nobody would ever think to call a male anchor and ask that kind of question.
Correct.
And make that kind of comment. But Mary Lynn said, well, I sure would like for someone to call and ask me about news.
Yeah, right.
Her name was Mary Lynn Roper. But we have those double standards of life. But what I find so unfortunate about this story, I mean, the punishment is going to be way disproportionate to the crime. I mean, she's being held essentially without bond. They've got a $250,000 bond. And a 27-year-old that's a teaching aide is probably not going to be able to make that, which means she's going to be forced to sit in jail, which means she's going to be forced to plead out, which means with the high-profile nature of this case, the courts are going to be under a lot of pressure, which Arizona's a tough state to begin with, but they're going to be under a lot of pressure to be harsh. And it sounds like the dad on the boy's side is really driving it, both parents, but it sounds like the dad is pretty irritated about it. And I think that a harsh sentence of imprisonment is over the top. But I'd be saying the same thing if it was the other way around. I would be saying the exact same thing. I think that this, where it was consensual, you don't want 13-year-olds consenting to have sex. Well, I'm not saying that's okay, but we don't also want to ruin a person's life for eternity because of that mistaken lapse in judgment. We would hope that she can make better decisions going forward, and not succumb to that temptation.
Well, very good. So she's pretty much going to go away for a while, I would imagine. She's going to have the book thrown at her, as the expression goes, right?
It's going to be hard knowing how tough they are in Arizona to not imagine her going to prison. It sounds like there's just too much overpowering evidence in terms of
there certainly is that.
The electronic chats and the probably a confession. She would have had no reason not to confess because the law enforcement would have told her they were there to help, and we just need to get this all straightened out and make sure it's getting straightened out all right. But I would expect that she's given a confession. Suppression of the confession is going to be very difficult. She's a educated person.
Oh, let me throw this at you too then. Do you think, to go back to the double standard thing, do you think that they're going to treat him as the quote-unquote victim and he's going to need treatment and all this stuff? Or I feel that it wouldn't, like if it were a girl, that there would be all kinds of she needs treatment and therapy, she's going to be scarred and all this stuff and PTSD. But I have a feeling that the boy will not get that same kind of conversations.
I suspect he will in this day and age. I suspect he'll get, they'll play that up. In fact, I think the parents have already filed a lawsuit seeking damages.
What are they going to get? They can't get anything out of the girl, the woman?
Sure can out of the school system, though.
Jesus.
And they'll say that the school was negligent, not properly supervising and screening. Of course, it's hard to screen for people when they haven't done anything.
Right.
But
they had a lookout, too.
So, it's hard to, I'd like to consider myself to be fairly thorough in employment interviews, but it's hard to imagine. First of all, I can't imagine I would be a principal of a school, but if I were an administrator of a school, it's hard for me to imagine how comfortable I'd be having that conversation. Because when you get to hired people to work in high school and middle school, what we used to call junior high settings, you got well-developed physical attributes on these young people, and so I would find it uncomfortable. But how are you going to have a conversation about that? Now, I just want to make sure. Now,
I know,
you
right?
Understand.
Yeah.
You understand that you're going to find some of these youngsters very attractive. What is your reaction going to be when one of them starts flirting with you? I mean, when you got a 15-year-old that starts, or I mean, how do you handle that? I just don't know how you're supposed to anticipate this stuff, and I don't know how you would adequately supervise to prevent it. The only way you can supervise to prevent it would be to have a camera monitoring everything that goes on in every square inch of the school building, which you wouldn't have enough people to monitor that, would you?
No, definitely not.
So,
all right.
Yeah,
well,
the young lady's life is ruined in all likelihood.
Definitely. And since I erroneously mentioned Maine before, I am going to talk about Maine now. So if you are a sex offender and you want to live in a multi-unit building, like a duplex or a quadplex, and you have a child living like across the hall, you are probably up the creek and not going to be able to live there. This is actually from MSN.com, but it says the law would ban sex offenders from some multi-unit buildings, houses in Maine. Wow. That's not cool, man. It's a really short article, so there's not a whole lot that we can dig into.
It looks like that it's also if they come through the same door. Now, what I'm trying to visualize, because I lived in Grand Rapids at one time, we talked about it a couple podcasts back, and I lived in an old home that it was such a large old home, they had divided it into multi-units, and at this point in my life, I don't remember if it was 5 or 6 units, but we all had our own unit, but we came in through the same common front door, and this looks like it has that common front door entrance. But what constitutes the entrance? I mean, is it the door that leads you into the house where you start going to your own? To me, I was very confused about this.
I can imagine that you have like an interior kind of duplex or fourplex where you have a common hallway to an interior door of your apartment. Not an, I don't know the right terms for this, but the door of my apartment leads right to the parking lot where my car is. But there are some apartments up the street where you go in a main door and then maybe you have some stairs to go upstairs, and the apartments are on the interior side. You have a foyer, I guess would be a word to use. Well, I can imagine that scenario where now you can't live there because there's a kid that lives in the hall across the street.
Across
the hall from me.
Convicted sex offender from living in a multi-unit that shares an entrance with a unit occupied by a minor. So I'm visualizing that 5-unit house I lived in. There's a minor living in one of the 5 units, and it shares a multi-unit building that shares an entrance with a unit occupied. So we all came in the same front door to get to our units. So it would seem like that this would qualify. And if Maine is anything like Grand Rapids, there was a lot of big old houses in Grand Rapids that had been subdivided into smaller living units.
So, and I always bring this up about a mutual friend that doesn't think that we need to do anything in the legislature. But this seems like exactly where we should be like, whoa, this is dumb. Here's the reasons why this is dumb, to keep it from actually ending up becoming any kind of law and derailing it before it gets there.
That is my belief, and I'm busily doing as much of that as I can right now in the way that I can to stop that. But some believe that you just hope that they magically figure this out, and they don't magically figure it out because there are too many issues that they deal with. And the law enforcement apparatus is telling them this is a good thing, and if they're not hearing from anybody else, I mean, this is going to get rubber stamped.
Yeah, we just lose by default. Well, to continue on with I guess sort of like a similar trend, in New York, since the Dems have taken over the House on that side of things, that they have extended out the statute of limitations to like pretty much forever practically. And now all kinds of people that had already passed some level of some portion of statute of limitations, they are like attorney shopping so they can bring their case and try and either sue civilly or criminally because they have like a whole bunch of extra time. I don't know what it was, but if the new statute allows civil claims in those cases until the victim is 55 years old. You could be 12 and now you've got like 40 years to figure out how to go get granddad for messing with you. And then criminal charges are allowed until the victim is 28 years old.
Well, I'm not as troubled. I'm troubled, but I'm not as troubled about the criminal side because 28 is still relatively young. I would prefer that they have not done that, but that's the trend across the country, and it's an example of where my my Democratic friends on one of the issues that I feel strongly about. I have difficulty with a lot of them. The Republicans we just had a vote here on a Senate bill that would raise the age on the criminal side to 35, and we got 8 Republican senators to vote against it, and only 7 Democratic senators to vote against it. Now that's 15, but the only problem is 15 was not enough, and it passed the Senate because we didn't get the requisite opposition. This is a trend that I don't see stopping. The advocates come in and say that the memories are first of all the minor is under the control of the adult, which is hard to argue that point with them. So you've got an 11-year-old that's under the control of the adult. So therefore you cut them some slack for not reporting. When they reach 18, 19, then they're no longer under control. What's the right amount of time to give them?
Right.
On the criminal side, but because there again, you're trying to put a person in a cage for a long time. And the more time you give them, the less fair it's going to be to the person who's accused, because it becomes more difficult for them to assimilate any evidence that would have been beneficial to them. If you were to take the statute of limitations off altogether, where they could charge something at any point, then you've got potentially decades and decades would pass. On the civil side, when you take it up to 55, that's troubling as well, because the evidentiary standard in a civil proceeding is not as strong. To prevail in a civil action, you only need a preponderance of the evidence. So you have the case like O.J. Simpson, where the criminal court acquitted him, found him not guilty, and the civil court found him liable for the death of Ron Goldman and Nicole Brown Simpson. And so you could end up with someone. I mean, I know I'm not supposed to question anybody's intention, but you could end up with something that's totally monetarily motivated that makes the accusation. And I know that we're flawed mortals and people do make false accusations. I think we just talked about it on last week's podcast, didn't we?
We talk about it pretty much every week.
The podcast before that, we talked about the Smollett thing that turned out to be a hoax.
Yes.
And it appears to have been economically driven. Well, I hate to tell you folks, when you open that door, anybody, including you people who think you're for it,
right,
you're going to end up being within the zone of this happening. You can say, well, I know I didn't do anything like that. That doesn't mean you can't be accused.
I would never do anything like that, though.
That's fine. But that doesn't mean the person can't accuse you of having done something. And
I was just playing devil's advocate for a second.
Yeah, I mean,
sure.
Picture someone, for whatever their motivations are, making an accusation against you and trying to take you for everything, and you've got a very low evidentiary standard in a civil case of just slightly more than 50%, and that's quite scary to me.
I do want to take an opportunity. I do struggle with this particular thing of trying to be compassionate to a victim of an alleged crime. But if you go back and listen to, if anybody doesn't know, I just listen to a mountain of podcasts. But so there's one that probably my favorite one is called The Skeptic's Guide to the Universe. And they did a really long segment about memory in last week's episode that I think it would be really good for people to go listen to. I don't have the time code of it, but it's fairly early in it. And it is just how flawed our memory system is. It is not like you put a VCR, a cassette in the thing and you press record and it records whatever is in its purview. You are constantly manipulating what got recorded. You are, you're some 50 years older than me. And, we're both males, but a female, like everything that you are about, everything that is your human being self, you envision the world differently. So now you're recording the thing in a flawed sense. If you're short, people just look tall. If you're tall, people look short. Your perception is just warped. And without corroborating evidence, it's just really freaking hard to do anything with someone's memory in a reliable sense to go, well, 14 years ago, what happened? Well, you've touched that memory so many times throughout your life, you very possibly do not remember what you think you remembered. And I just want to make that statement, that assertion that it's really hard, but it's something that you have to keep in mind, that people do not remember what they think they remember.
We would be hard pressed to remember everything we say on this podcast once we get off. I know when I recount a conversation with someone, I don't tell you exactly what I said because I don't know what I exactly said. I'll reconstruct the conversation, trying to do the best I can, but you don't remember what you said. And as the time goes by, the way I square this up with myself is I just tell people that you do believe in fundamental fairness, and you would want a person accused of crime. Let's say you were accused of a crime. You would want the system to be able to treat you fairly. You wouldn't want the system to presume anything about you. Just put yourself on the accused side. And since I know you're a fair person, you would want to be treated fairly. We can't give this person a fair trial 34 years after this allegation. We can't. It's tragic. We're sorry, but there's no way we can give them a fair trial. Now, if they want to come in and admit it, if you want to come in, I mean, Hastert admitted he was beyond the statute of limitations. For those who don't know the name Hastert, former Speaker of the United States House, Dennis Hastert from Illinois, he admitted when he was being sentenced for his federal crime of structuring transactions and giving a false statement, he was paying hush money to one of his victims. He admitted at sentencing he did those things. But if the person doesn't admit it, I would want to even treat Hastert fair, even though I didn't think too much of his politics. He deserved, him and Roy Moore, everybody deserves fairness. And I just try to appeal to people's fairness, that you would want fairness. You would want to be treated fairly. You won't have anybody disagree when you ask them first. You would like to be treated fairly if someone accused you of something, right? And they'll say,
but
yes.
Won't they then pull it? But they'll pull it back and say, well, I would never do anything like that. And so
that's exactly what
that's not.
But you've
got them but that doesn't make the argument. Go ahead.
But you've got them to buy into that they would want to be treated fair. If someone were to make a false accusation against you, would you want us to believe it out the gate without anything to corroborate it, or would you want us to treat you fairly and would give you the benefit of the doubt, which the Constitution required? They would say absolutely yes. And they would say, okay, now we're flipping the scales now. You're making an allegation. You do want this person to be treated fairly, don't you? And it's hard for them to backtrack from that because they have said that they believe in fundamental fairness. And we can't give the person a fair trial decades later.
Right. There was an interesting decision that came out of SCOTUS this past week, and you can find it over at SCOTUS blog. The URL is just way too long for me to even try and say anything. But it's an argument analysis. Court poised to rule for challenger in dispute over constitutionality of sex offender law. This is it's an excellent read, and the way that the justices were asking questions, it feels like it's a good thing going on.
Well, why did you say that a decision came out? I didn't know a decision has come out.
This isn't a decision?
Well, not arguments are not a decision. No, they're not. I think
okay.
It says court poised to rule, but have they ruled yet?
Okay, I guess I'm confused on terminology. So this is just them asking questions, and I guess it's called oral arguments?
They held an argument. They heard oral arguments in a case that they're going to rule on by June. Okay.
All right. So we only have a few months, but it seems like it's in our favor because of the way that they're asking questions, including like our favorite Neil Gorsuch and Kavanaugh.
Well, I would caution people that when you listen to oral arguments, you should not conclude anything from that. It can be very misleading if you listen to oral arguments, because those arguments are designed to get the parties to reveal something and make a mistake and blunder, and to get concessions out of them. But it doesn't necessarily mean that that's the way that the justice is leaning. Court watchers through the years have been sorely disappointed by pronouncing how they think the court's going to rule based on oral arguments. The Affordable Care Act, it was supposed to be declared unconstitutional based on oral arguments, and it wasn't.
All right.
So, yeah, I could go on and on with people. The civil commitment of sexual offenders, the recent case, and the name is escaping me, in the last, when I say recent, in the last 5 or 6 years, it's recent.
Okay.
There was a case where there was a lot of skepticism from Justice Scalia, but he voted to uphold civil commitment. So you just, when you concentrate on oral argument, it's fine to look at it and listen to it and read the transcripts, but don't try to predict what this court's going to do, or any Supreme Court, because the oral arguments are just that.
Do you want to then cover some of the details of what is going on in this case, though? Because I don't think we've covered this at any point in the past.
Having not read the briefs, I can only cover a little bit of it, and it has to do with supervised release on the federal system, and what you have in the federal system since the Reagan reforms of 1984, the criminal justice, the Reform Act of 1984. We did some major changes in our federal system in 1984, both to bail and to the sentence, called the Sentencing Reform Act of 1984 and the Bail Reform Act of 1984, and they abolished what we had in the way of good time and what we had in the way of parole in the federal system. And it's been so long since we've had that, I don't remember what portion of a federal sentence you had to serve before you were eligible for parole. It was some small portion, less than a half, and you were eligible to be considered for parole. And they abolished that, and they put in these determinate sentences that we have now of the sentencing guidelines, where you get a range of sentencing options based on all these formulaic grid that they have.
It is crazy. I hear about it often on another podcast. It seems very complicated.
And then following that, you have a period of supervised release, which took the place of parole. And supervised release is not exactly probation, because Congress wanted it to be the helping hand part that you need when you come out of prison. But a helping hand also can involve conditions that you need to follow. Where supervised release gets tricky is when they impose conditions that you violate. So if they give you a period of 10 years supervised release and you violate, well, that 10 years may take you beyond what the original jurisdiction was for your crime. So if you violate supervised release, then the judge piles on an additional 5 years. Well, it gets very problematic, because the facts that'll revoke your supervised release are not decided by a jury. And the evidentiary standard for that is much lower. It's like a probation revocation. The rules of evidence are more lax in terms of what's admissible, and the standard is not beyond a reasonable doubt that a jury or a judge in the guilt or innocence phase would have to decide. So the Supreme Court is expressing dismay about putting a person back in prison for years for violating technical conditions on a much lower evidentiary standard. And that's what the crux of this is that, well, why are we allowing judges to put people back in prison for years beyond what they would have been able to have been sentenced to had they been sentenced for the crime originally, and the judge doesn't have to find the violation beyond a reasonable doubt just by preponderance of the evidence.
It feel like I think where I am, if you do some violation like one day before you come off, and the judge says, okay, well, I'm going to revoke the rest of your probation and you have to go back, so you're going to do one more day in prison. This feels way out of whack with that. I mean, that's my understanding of how it works in this state. So, and I know feds are different, but it just feels like, hey, you've got 1 week left. You've done this violation. Oh, here's another 10 years. Like, for what? Hey, you missed curfew. Like, what?
Oh, well, this if you're going by the SCOTUS blog, and I'm only going by the SCOTUS blog. This is not my opinion, but the people here seem to think that the three really conservative justices, which are Alito, Thomas, and who's the other one, that's conservative trio, are squarely on the side of the government, that they can do that. But even some of the less conservative judges like Roberts and Gorsuch seem to have real problems with it, and even Kavanaugh expressed alarm. So it looks like, if they've got it right here, that this is going to be very problematic for the government. It may jeopardize the whole supervised release system.
Interesting. Do you think that would filter down to any of our people?
I don't see how it couldn't.
Okay.
Well,
that's good.
The people that have sexual offenses in the federal system, there are a heck of a lot of them. It's a significant portion. I don't know if it's 20%, somewhere in the 20% range, but a significant number of the federal offenders are for downloading, possession, distribution of porn, interstate solicitation, travel interstate lines to meet a minor. Of course, there are always fake minors you go to meet, but there's a significant number of people.
Fake minors. Who's the victim if it's a fake minor?
I just don't understand how you can be 50, 60, 70, 80 years old and actually believe that a 15, 16-year-old is wanting to have sex with you. I mean, have you forgotten when you were 16? Did you think a 60-year-old was hot? Somehow or other, you think that they actually are going to think you're hot.
And just in the chat, someone said the PO said that if you violate, your probation starts over. That doesn't sound at all right, but I mean, it could be true, but that just sounds horrible.
Well, it would be depending on the state. I don't think that person's talking about federal, because nobody hardly gets federal probation. In the federal system, the probation is almost unheard of. Supervised release is not the same thing as probation.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible.
And here we go from Reason Magazine talking about sex trafficking, but it apparently is the authorities are walking back big claims about an international human trafficking ring involving Patriots owner Robert Kraft. It's like we're further and further trying to criminalize just anything sexual because maybe it makes us feel oogie that people are having pleasure, I guess. But this is about a massage parlor in Florida, and like there are allegations that the women are like in bondage and they can't leave. But when you actually dig in and start reading anything about it, there's like they could go out on the street and ask for help if they really wanted to, but they didn't. I don't know. This probably goes along with the FOSTA SESTA stuff where they shut down personals on Craigslist and all this. Like we're just making more and more stuff illegal for something that doesn't even really exist. Not to minimize people that are actually trafficked and are actually victims of this. But I don't think that this is the right place.
Well, I feel similarly. I think that human trafficking is a horrible thing, just like I feel rape is a horrible thing and condemn it both in the strongest of language possible. But I feel like when we describe rape in a way that demeans it by calling things rape that's not, the same thing with human trafficking. People are actually human trafficked. That's not an imaginary thing. It does happen. People in poorer countries, and even to some degree in this country, it happens. People that are exploited when they are young and they run away to get rich in the movie star industry, and they find out that the only really thing they have to sell is their body. They end up getting trafficked. But let's don't demean those people who are victims of a real crime, a real horrible crime, and expand the definition of human trafficking so much to include things that people are doing because they choose to do it. I would venture to say, I'm guessing, but I suspect these women were choosing to be there. I don't think they were brought in bondage and they were held against their will to do that. Is it an ideal, optimal setting for a person to sell sex? Probably not. But guess what? It's been going on for a long time. I'm not
oldest
sure
profession, as I recall, right?
Yeah, that's what I've heard all my life. I just don't understand how that we diminish the serious crimes by calling something. I've even heard the definition of human trafficking should include people who are in college that sell their pictures to to pay their way through college. Really? Are you being human trafficked if you go to an agent that says, I can get you whatever $1,000 for a photo set? Is that human trafficking? Is it exploitation? You're getting something in return. You could go down to the local Denny's and wait tables and get yourself $10, $15 an hour doing that if you wanted to.
Go sell plasma.
You could do that as well. But if you were blessed with attributes that people want to pay to look at and you want to voluntarily sell those, I just don't have a problem with that. I know the people on the religious right, the real conservative religion people, would say, well, ought not do that because God made that for the enjoyment between man and wife. And I understand that. I've heard that a long time. But I don't want to be the morality police for people who want to do things of a voluntary nature. And I'm not really sure what went on in this thing with the NFL owner. But I just suspect there's a lot of sensationalism and a lot of overblowing because they try, once they spend a bunch of money on running these stings, they can't just say, well, we ran the sting for the last 6 months, didn't really find a whole lot going on here. We spent $270,000 of manpower, and, well, we found out a couple of people that have standing in the community are going and hiring hookers, but really ain't a whole lot going on here. I mean, that just isn't the way it goes. That's not the way you justify. They have to overblow what they find in these operations.
Well, this next thing comes from the federalregister.gov, and there's nothing for us to do with this one other than go, if you're a tier 3 offender and you are a veteran, you can forget having your courtesy, I don't know what the right word is, a courtesy burial. So you're going to have to do it on the economy, and you don't get that as a VA benefit, I guess we could say. So that's really awesome.
I think it applies to being buried in a national cemetery, aren't you?
Correct. Yes.
So you forfeit that. I think it would be an earned thing that you would go with one of the many benefits that you earn from the service. But it seems like to me that the logical thing is, why stop there? Why not? We shouldn't even have these people going into VA hospitals and clinics for treatment.
Or VA loans, or GI Bill. Just forfeit everything if you get convicted of an offense.
I think they've already done some damage in terms of accessibility to loans. But this is totally kooky as far as I'm concerned. Now, if you could make a rational argument, and that's the big if you could make a rational argument, which I don't believe that I've ever heard one, but if you said, well, we need to keep them out of the hospitals because there might be grandchildren there. If you could put forth that rational argument, I'm waiting to hear the rational argument for a person who's in a cemetery arrested.
Yes, well, you've scarred the conscience of the United States.
Well, but you're arresting, so I don't know how that this would do anything to scar anybody. To me, it's about as phony as an argument as about the same-sex marriage. They say, well, it destroys the institution of marriage. Really? I don't understand how you cannot be happily married and be committed to your spouse. And I don't know how somebody else is doing. I don't understand how a person who served the country and goes to their final resting spot, I don't know how that does anything to anybody. I'm at a loss to figure out how it does anything.
Yeah, other than to just shame you some more.
I mean, I don't think a single person who's born in the uniform hasn't made a mistake and broken laws in their life.
All right. Well, so I said I didn't want to cover it long. Here's some fun out of Iowa that there's a guy who got convicted of a sexual offense, and like I have very minor problems with this one. Like, it's very recent, but a registered sex offender allowed in Boone schools. This guy's like, hey, I would like to be involved in my kids' education and maybe go to some school functions, basketball games, concerts, whatever these things are. And to me, it feels rational that he had to talk to the school superintendent or principal or whatever and get permission to go. And he has to be there no earlier than 15 minutes before the thing. So, hey, get in there, get your popcorn, go get your seat. And then when the presentation is over, you have to be gone within 15 minutes. Grab your coat, say hi to your kid, and like out the door. It doesn't sound unreasonable to me, but of course the parents are like, well, he's already proven that he can't be trusted around kids, so when we go to these events, I'm going to have to make sure that I stick closer to my child, a mom said. Like, really? Like, you think that just because this guy is present that he's going to, like, ooze icky on your kid or something?
Well, I'm struggling with this one. I have to admire the school district in Boone because they said they have no intention of changing their policy. And of course, that could mean that they don't serve on the school board beyond the next election because school boards are generally elected. But I don't recall anybody ever showing me any evidence of it at a school function that a parent or a guardian being a part of that outing, be it a field trip or anything to do with a school function, be it a sporting event. I just don't remember anybody validating any sexual impropriety by the parent. I've not heard of that. I mean, I go back to the Lincoln administration. How far do you go back? You go back to Teddy Roosevelt, right?
I can't. I like even in all of this stuff. Same thing with Halloween. Like the kids are under heavy supervision. Not even necessarily supervision. They're generally in crowds. Like, hey, they're hanging out with their buddies. It's like it's probably not going to happen in a group setting of any sort. I don't think someone's going to act out and be like, oh, hey, there's 100 people around here and that chick looks kind of hot. Let me go try and see if I like, hey, kid, do you want to double your lunch money? It's just not going to happen that way. I don't think.
Well, I've not heard of it. It's bizarre. But you have to cut the lady a little bit of slack that was in the interview about if you've been told for the last 20 years about how dangerous that these people are. I mean, it's kind of a natural reaction that she has because that's what she's heard on the news for so long.
Right.
It's been.
Yeah. All right. I totally need you to cover this one. This is from Courthouse News, and it's the Supreme Court expands precedent on ineffective counsel. I understand what ineffective counsel is, but I don't understand how this plays out, and I kind of don't understand how it applies to us. So please explain to me.
Well, I don't understand what you don't understand about it, but
it's a bunch of words, and I understand the words, but how that all fits into... I mean, ineffective counsel, like your attorney didn't represent you as well as they could.
Well, it's a 35-page opinion. Do you think we can link to it in some way? It's probably going to be overly complicated, something we can talk about repeatedly, but it's a new area of law that's opened the door because the Supreme Court has decided that they're going to crack the door a little bit more for ineffective assistance counsel. It's a very tough standard. When you're trying to undo a conviction, since the majority of cases are resolved by plea, it's very difficult to prevail on ineffective assistance of counsel. And about 5 years ago, which is not that long, there was a couple of cases that came down where a plea offer had not been communicated to a defendant, and the court said that was ineffective assistance. And this deals with a person who had a plea that waived his right to appeal. And usually those rights to appeal don't exclude every type of appeal that you could imagine, but you may be excluded from appealing your sentence. You may be excluded from appealing the some aspect of the evidence collection process, or how they interpreted the statute to apply to you, that you've got 4 counts, whatever. But this plea included a waiver of his appeal, but then the guy decided he wanted to appeal, and his attorney refused to file a notice of the appeal because he said that he couldn't do it because it violated the plea agreement. He had no right to appeal. So what the Supreme Court held in this case was that the notice of appeal should have been filed to preserve his right. So that in itself was ineffective assistance in not filing the notice of the appeal. And so the government argued against it, but he got the favorable decision from the Supreme Court. Sotomayor delivered the opinion of the court, in which Roberts joined, and the liberals crowd always joins on stuff like this. So it was Sotomayor, Ginsburg, Breyer, Kagan, and Roberts who made the opinion. But those who have pled out for any type of offense are going to have one more mechanism available to them if they fit within this narrow window here of this decision to go back and attack on ineffective assistance, which is a tough standard to meet. But you got another thing that opened up to you now.
All right, and then also Kavanaugh must have voted because it was just Gorsuch, Alito, and Thomas were the ones that dissented. So that means Kavanaugh was on the side of supporting this.
I think he joined in part of it.
Okay.
It says Gorsuch joined, and which Alito joined parts 1 and 2. So yeah, it's a pretty good decision. But like I say, we probably need to spend a little more time on it as we go along. I'll frequently come back to things, and I'll have to talk to practitioners and see how they feel about it and how they can actually develop their appellate practice around this decision. And see if it's going to be something that's going to be meaningful, if it's going to apply just a very, very, very small number of people.
All right, then. This would be the time that I wish I had the cops theme song where we're like, bad boys, what you going to do? This article comes out of Narsal, and routine compliance checks are anything but. Here it is on some Tuesday night, Thursday night or something. You're sitting at home. You're in your underwear, sitting on your lazy boy with the chair and L for loser, and you're kicked back, and there's a knock at the door, and you open it up, and there's 8 officers and a camera crew to just check on you and make sure that you're doing what you're supposed to do. This is definitely like, how much does this freaking cost? This is out of Oklahoma. And like, why do we need to put this much force out in play to go make sure that you're 1,000 feet away, that you don't have decorations out, you don't have whatever? I don't know, but why do you need 8 officers to do this?
It's because there's a pot of money available to do it. There's compliance checks have been provided by the feds since the passage of the Adam Walsh Act in 2006, and it's a big business, but it's one of the reasons why I want to continue to argue that it's a civil regulatory scheme. And
right.
With a civil regulatory scheme, you don't have guns and tanks and armored personnel carriers, and you don't approach people in such a fashion in a civil regulatory scheme. So again, I try to buy into what they say. You say it's a civil regulatory scheme, right? Okay. Well, yes. If it's a civil regulatory scheme, let's take it out of the hands of law enforcement, because civilly regulated people do not have to face guns and tanks at their door. And I'm exaggerating about the tank, but I'm not exaggerating much, because these people show up in the garb, the full garb sometimes, where you think that you've got a SWAT raid about to go down.
Right.
And they'll have their hands on their weapons as if you're going to fire at them. And it's very discombobulating to the family members, to the neighbors who see that going down. Can you imagine what your neighbor thinks when you've got 6 or 8 armed officers with their hands on the trigger and banging at someone's door, carrying on like that? Can you imagine how that would make the neighbors feel about that particular home?
But what about your family and all? Your kids, your wife, your
what
good
about the
grief,
kids
man.
If the kid answers the door,
can you imagine? Can you imagine? The kid just like stands there and wets themselves, and there's a puddle of pee because the cop's standing there with a gun drawn right in the kid's face.
So yes, I can imagine it, and it's a tragedy. I wish I had an answer for it. Litigation is one answer, which there's not enough of. Litigation challenging their authority to do this, and they're going to fight back and say they have the authority under the community caretaker doctrine. They're going to say that they are charged with tracking and keeping watch on these terrible group of people, and that this is a part of their community caretaking responsibilities. And it's going to be up to the offenders to document this by camera, by photographic evidence, by witness statements about how excessive it is. And we're going to have some test decisions on terms of how far they can go with these so-called compliance checks. But the best way to end the compliance checks is to take it out of the hands of law enforcement.
I totally like your idea. I don't know which martial arts I used to sort of know, but they're in certain martial arts or even like wrestling, whatever, use their weight against them. And to me, that's what you're describing is that, hey, if this is a civil regulatory scheme, why are you guys coming in all the tactical gear? So use their argument against to almost like pull them in to then flip them over so that they end up on the defensive end of trying to defend. Well, if it's civil regulatory scheme, then they shouldn't be out there in tactical gear and SWAT trucks and whatnot. Like the DMV people don't drive around this way. That's a civil regulatory scheme. So why do you need these people out and all this kind of
absolutely
just oh my God.
You have to join them in their arguments, and that's what I try to do. I try to co-opt their arguments and use them against them, and it's civil regulatory. Quit fighting it. Agree with them. And let's build a civil regulatory scheme.
All right then. And this one made a bunch of news. This one ends up coming out of Snopes. The title of it is, "Did California Democrats introduce an LGBTQ bill to protect pedophiles who rape children?" And unfortunately, the answer is only mostly false, because it's only like for the most terrible of the people that it would extend to. But so this started just making rounds, and I picked up on it because I was like, wait a minute, this is garbage. And it turns out to like pretty much be all false, that's not what this thing is saying. But, you know, and I have a link to the source article to see where it was originally reported. And it's just bizarre that people would take something and just grab a couple of buzzwords and then report on it in such a way that makes you think that the Democrats in California, it's really bizarre.
Totally fear mongering. It is.
Yes.
They're trying to apply the same excuse relief from registry. I shouldn't say excuse, but the same registry relief that I think is currently available to those who have same sex, because right now it appears to be applied to hetero activity, if I've got it right. Did you read it the same way?
And yeah, pretty much. And so what Snopes says is what's false is this. It says the bill would not shield anybody from the requirement to register as a sex offender. Rather, it would leave that decision in eligible cases to the decision of the presiding judge. Okay. So, you know, if there's a certain condition where it does apply, then the judge can say yay or nay. But it's not like it makes it all of them.
Well, it's within 10 years of the minor's age, and it has to be consensual. And then but it just removes it that it only be for heterosexuals, the way I understand it. And feel free, Californians, to correct us if we're wrong, but that was what I understood from my quick read. And
and I didn't want to dig into that one for very long because we're running long as it is. And we want to cover like the feature thing, which is this Third Circuit decision. Is that right?
That'll be from the United States Court of Appeals for the Third Circuit.
Which states is that right off the bat?
That would be Rhode Island, New Jersey. I
those
believe.
People.
It's a bunch of darn liberal do-gooders and
that's all like the blue states up there. You got West Coast blue, you got Northeast Coast all blue. All right, so it's the liberal do-gooders, and what are they talking about?
Rhode Island is actually pretty conservative from what our people are telling us up there, but it's only 3 states, I think: Rhode Island, New Jersey, and Pennsylvania, and I think Guam or the Virgin Islands or something.
What was the decision about?
This decision is potentially potentially significant. It is significant in the Third Circuit already, but let's make sure I've got those Third Circuit states right. I'm going to take a look at the map of the circuits. I don't want people to get excited and think they're within the zone of the Third Circuit, and then it turns out they're not. So we've got to get this right. So the circuit court system is. I should have a hot link to this by now. The Third Circuit is Delaware, New Jersey, Pennsylvania, and the Virgin Islands. And
huh? Wait a minute. You said Delaware, New Jersey, Pennsylvania, and the Virgin Islands.
Delaware, New Jersey, Pennsylvania, Virgin Islands, not Rhode Island. So that's why I wanted to double check it. So Rhode Island is
right. But Virgin Islands is like 2,000 miles away. That doesn't even make sense. You
got to put them somewhere. So so that's where they've put them. So it's one of our smaller circuit courts of appeals. There's in the Third Circuit there's 14 judges seated. The First Circuit is the smallest with only 6 judges seated. Then you can go to the Ninth Circuit, which is the largest in territory and population. There's 29 judges. So the Third Circuit is one of the smaller ones, but not the smallest. Okay, so what the case is about is a process called habeas corpus, And a habeas corpus is kind of when you're getting near the end of what you can do to challenge your conviction. Habeas is one of the final remedies that people look towards if they've done their direct appeal, if they had the right to a direct appeal, and they've done their post-conviction relief processes in their states. Then you have the opportunity to take your claims into a federal district court if you're raising federal constitutional claims, and you could and so you're looking at the Third Circuit Court of Appeals, which is the second highest tribunal in the country. There are 12 circuits, Court of Appeals. There's 11 numbered circuits, and then there's the D.C. Circuit. So this is one of 11 circuit courts of appeals around the country, and that the D.C. Circuit is really a full circuit, but it's called the D.C. Circuit. It doesn't have a number.
All right. And you often talk about, we talk about these different things, but a habeas is just a vehicle to get a thing into court, correct?
Yeah, it's an old ancient writ of basically bring me the person, to bring me the individual, and so it's evolved through time. When you go back to ancient times, we didn't have probation, parole systems. We didn't have the form of community control now. So the person was in a custodial setting in physical custody. But as time has evolved, habeas has been recognized to extend beyond the actual physical custody. So in order to bring a federal habeas claim, now we're only talking about federal. This is a federal habeas claim. You also have state habeas that may have more generous accessibility or less. I'll talk about a state that has less availability, and then there are states who may have more. But the federal definition of custody is expanded to include probation and parole, supervised release, and even unsupervised probation, because those are controls and restrictions. Even under supervised probation, you can have conditions that the average citizen wouldn't have imposed on them. Well, the question has been for a long time is, does sex offender registration qualify for in custody? Because you have to be in custody when you bring a habeas petition. You're asking the court to order your presence and to give you relief from a custodial situation. Well, as a fundamental requirement, you have to be in custody before the court can release you from custody. So this individual brought a petition saying that he was in custody of the sex offender registration. And no circuit has recognized that merely registering as a sex offender meets the in custody requirement until the Third Circuit did. And that's what makes it so huge, is we've got a Circuit Court of Appeals saying now that if you want to file a habeas petition, if you are in custody in Pennsylvania, this was regarding the Pennsylvania registry, that was highly enhanced in 2012, which has been determined twice now by the Pennsylvania Supreme Court to be punitive and an ex post facto violation. But the determination that was punitive gave the Third Circuit something to hang their hat on. They said, well, it certainly does have a lot of controls that are similar to probation in terms of what you can do and can't do. We're going to provide a link to the decision where everybody can read it. But the analysis is fantastic, because they go through like the internet restrictions that you have under probation, and that how quickly you have to, similar to what you have under probation, just having to be registered, all those restrictions, and how quickly you have to report them, and how it deters your usage of online identifiers and creating accounts because it's not practical to report them. And so that's an inhibitor, and it constrains the person's behavior. They go through this beautiful analysis, and they say, well, it sure looks like custody to us. But they didn't say what people wanted to say. I've already had a half dozen conversations with people saying,
I know what you're going to say too.
Well, I can challenge Dow with a habeas. Well, not so quick, because they didn't say that all the states in the Third Circuit, which there's only a few, they didn't say that their SORNA is unconstitutional. They didn't say anything. Actually, they said that the Pennsylvania Supreme Court has given us guidance, and they've told us in the case of Coppolino and in Munez that they find that Pennsylvania's registry is punitive. So we're going to take their word for it. And we are going to say that since the registry is inflicting punishment, that is enough to get you the custody status that you need to file a habeas petition in Pennsylvania. Now, I don't know that you can make the same argument if you live in Delaware, because I don't know of any finding in Delaware that's found the registry to be punitive. Do you remember any such thing? I don't.
I never have heard anything coming out of Delaware other than Joe Biden.
And I don't remember anything out of New Jersey finding that the registry inflicts punishment and violates an ex post facto. So we've got a situation here where in Pennsylvania, thanks to 2 rulings from their state Supreme Court, that you've got the opportunity to use the registry as the jurisdictional hook to file a habeas petition. That's all this decision said. It didn't say anything more than that. It didn't determine whether the guy should get relief. He doesn't want the soup up applied to him of what, because when he did his plea in 2010, he didn't have the requirements that were added in 2012. So we don't know if he's going to get that relief or not. At least not through this vehicle. He may get it through the other relief, through the Menez case and through the other decisions in Pennsylvania. But all this did was directed the trial judge at the district court level to allow him to proceed with his habeas petition. It could be that after he goes through that process, the district judge could say, I turned you down for other reasons. But he is able to air his grievance in a habeas court now if this decision stands.
Does that then open the floodgates for like everyone in Pennsylvania to go file and like gum up the whole system with these habeas challenges?
It certainly would. If I were the Attorney General in Pennsylvania, and if I were even the district courts, the federal district courts, there, I would be looking at how many people's on our registry, how many of them have been. Boy, we're going to have a lot of work to do. And so it would be very surprising to me that if there's not a cert petition to the U.S. Supreme Court to try to overturn this decision. I mean, we can't have this flood of habeas petitions coming in here from these people who not have to comply with the registry.
But then, I think I asked you this a handful of days ago. Then is it? We talked about this in potentially filing a challenge in my state of you wouldn't want to bring 8,000, whatever individual challenges. Then you would try and like kind of force the court's hand to make a large decision. I don't want to use the word class action suit, but that's the concept that I'm thinking of, that everybody joins into one big thing so that there's one big decision made. I think you called it like judicial efficiency or something like that.
Well, that's the whole purpose of a class action lawsuit, and that may be what they ultimately do in Pennsylvania, because it's high time that we have a report from Pennsylvania and do a conference call about what they've done. There has been very little movement to enact to extend the relief that was granted in the Menez case beyond the challengers. So if I were the federal habeas courts, I wouldn't want those old challenges flooded into the federal court system. They've got other things they'd rather be doing than dealing with people in the sex offender registry. But it does possibly create more pressure to resolve the issue of whether or not the registry needs to be all the people who would fit the same fact pattern of the Menez case. If they go ahead and get them relief. And that's the whole purpose of a class action, is to certify something where the claims are similar and the efficiency serves the efficiency of the judicial system to resolve the claims collectively rather than going in individually. But I can see potentially a lot of habeas petitions what Pennsylvania would want to do is they would want to go back and ask the Third Circuit. You can ask for a full review, an en banc review. You would try to get the full court to flip the panel. It was these decisions are decided by 3-judge panels. So you would want to first see if you could flip the panel by having an en banc review. They don't grant very many of those, because if they did, there'd be no point in splitting in the panels. Everybody would just go to the full court. And the full court could never hear all the cases that they hear in the panel reviews. So you're not. It's a pretty tough standard to convince the court to convene and to get all. I think I said 12 to sit as one tribunal and resolve this case. That's not likely to happen, but it is an option. That would be the first thing they would do. It would be to seek a full court review. If that fails, then they would file a petition for cert with the Supreme Court. In the meantime, they would go back and ask the habeas court, excuse me, not the habeas court. They would ask the Third Circuit to stay any further action on this until they can resolve it, because you don't want. I mean, how many thousands of people on the registry in Pennsylvania?
Let's just make the assumption it's 20,000. That seems to be a safe number. 20 or 30, 40,000, something in that ballpark.
Yeah, you don't want that that flood of activity in the court system. So this now they do at the end of the opinion. They do strive to tell people that this is a narrow opinion and that don't assume anything. But people are going to assume a lot of things because people want relief. I mean, this is horrible. But if you look at the very end of the opinion, toward the end of it, they do caution that this is a narrow ruling, that they're not trying to encourage the floodgates.
But why did they even grant to hear this particular habeas case?
Well, habeas is a right. So the person that filed their habeas petition at the district court level had the right to that, and you have the right to an appeal. So this is something that they had to hear by right. This is not, they didn't get their choice, and that they could have ruled against him, but they were persuaded by the arguments.
Okay, all right. So I mean, you could file habeas for anything and be like, this doesn't apply, so no.
Well, that's what the district court said. The magistrate.
So I guess kind of like granting cert. So you'd file a cert petition to ask will SCOTUS, will you guys please hear this thing? And they just say no. That's similar to this. You have the right to file it, but they can say no.
Well, no, they have to hear your habeas. They have to make a decision on your habeas. They can gut you like a fish. But
okay.
But they do have to decide your petition unless you're outside the bounds of being eligible for habeas. They had always gutted these by simply saying you're not eligible for this relief because you're not in custody.
Which then leads directly to, so what are the basic requirements to file?
Well, you have to be in custody of some form. If you're going to file a federal habeas, you have to be in either prison or under supervised release, probation, parole, or something where they have significant control over your daily lives. And that's
where this kicks in. Okay, and because I'm assuming that the people that are filing this are outside of that, but because of the restrictions of the registry, internet restrictions or living restrictions, etc., it starts to look like custody, correct?
Yes, they have determined that with all the restrictions, Pennsylvania could not help themselves. They kept piling on restrictions like a lot of other states. And since they couldn't help themselves, they finally got a court to say, well, we hate to do this, but this sure looks like custody to us, so therefore this is a remedy available to them. Now the Supreme Court could do like they did in the Munez case. They could refuse to hear this. It's hard to speculate on what the Supreme Court is going to do because I don't have a direct pipeline to them. If they were to affirm this ruling, this would open up the entire nation for people to use habeas as a vehicle to challenge aspects of registration. I can't imagine the Supreme Court would want to do that.
Right. Wow. This is in the weeds stuff again. This is like big propeller head legal stuff of like where this fits in, threading the needle. It's funky to me. It's fascinating and neat. This is weird stuff.
I can't imagine that they would want to flood the courts with habeas petitions. So it might be that their best strategy would be at the Supreme Court would be do the same thing they did in Munez. The same thing they did in Does versus Snyder out of Michigan is to reject the cert petition, which would leave this as a limited ruling within 3 states. And particular with the way that they narrowed it, they have basically made this only applicable to Pennsylvania. They say many of our this is in limits our rule. Many of our sister circuits have predicted that a ruling such as this one we announced today would render the in custody requirement of habeas statute superfluous. Our decision today raises no such concerns. We do not hold that any collateral consequence of conviction can support habeas jurisdiction. Rather, we hold that the custodial jurisdiction requirement is satisfied by severe, immediate, physical, and according to the state's own definition, punitive restraints, now they mean the state Supreme Court, on liberty that are imposed pursuant to and included in the judgment of the state court, which is the one here. Truly collateral consequences such as inability to vote, engage in certain businesses, hold public office, or serve as a juror are not analogous to the restrictive invasive regime created under SORNA's registration requirements. So don't get yourself all palpitating because they didn't say that anything will trigger the in custody definition. Did you meet that definition? They said that in a state where the Supreme Court has said that the registry is punitive, and you have all these restrictions, which we've outlined in this ruling, including the internet restrictions, that might be enough to trigger the in custody analysis that you could actually meet it. That's all they've said here. So like I said, the best thing for the Supreme Court to do would probably be to say, we don't want to cert denied. And then Pennsylvania will have to clean up its act and decide how they're going to implement what their Supreme Court has said as a punitive regime, and they're going to have to fix that. I think it's additional leverage to get Pennsylvania's problems fixed.
Right, and then if you find states that have similar regimes, that you could then use this to push your argument up the ladder. Where if you have a more lenient state, then you just have less grounds to stand on to try and do this. But if you have, I'm thinking Oklahoma, just because we covered the article where you have the freaking tax squad come up at your front door, that feels like custody.
Sure does.
And there was the thing in the different videos that David Feiga has put out where the woman, hey, tomorrow you can't go to the park anymore. That feels like custody.
Does.
So it feels so. Here's where we can keep building on the mountain of, if you're in a state that has these things, here's the elements that you can pull in to build up your little sandcastle for you to start trying to try and knock some of these things down. And let's just say it again. Each state has their own registry scheme, and each state has to be fought individually. But other states can give you tools for us to go fight there. But again, there's not going to be that one magic bullet that's going to take down the whole thing.
There's never going to be a magic bullet ever that will take down the whole thing unless we choose through a political process to stop doing this. There's no court ruling that will take down the whole thing. Ever, ever, ever.
I hear you.
So I like their conclusion. The writ of habeas corpus, quote, is not now and never has been a static, narrow, formulistic remedy. The scope of the writ has grown in accordance with its purpose to protect individuals against the erosion of their right to be free from wrongful restraints upon liberty. SORNA's registration requirements clearly constitute a restraint upon liberty, a physical restraint not shared by the public generally. So they're telling you that habeas. Now you look at a state like Arkansas, you have to be in physical custody to file a state habeas there. They take a much narrower view of habeas corpus than the feds do. If you're not in a physical custody, you will not be heard in a state habeas proceeding in Arkansas.
It feels to me like in many of these states, they are aggressive about this stuff because they have an enlarged medulla oblongata.
A what?
It's an area of the brain, like alligators, they're aggressive because they have an enlarged, like the center of their brain. It's just like it. But there are certain people that are just aggressive because maybe they have just like, maybe their brain is wired wrong.
I never do what that word was. So you learned me something.
It's today. A little peanut. It's the little walnut size, like center of your brain. It's the fight or flight section of your brain.
All right. I appreciate that.
Hey, you're welcome. That's why I'm here. Because I don't know the legal stuff, but give me some bullshit, crazy kind of trivia out there. Maybe I know something. Huh. Well, so give me your opinion on like the larger scheme of things. Does this literally only apply in Pennsylvania, or does it like start to spread out and get used elsewhere?
I would say that literally it only applies to Pennsylvania. In reality, if the Supreme Court were to get a cert petition, and if they were to deny review of this case, this thing's going to be springing. You're going to be seeing people argue this all over the country, that they're going to cite to this as a persuasive circuit court opinion, well reasoned, well analyzed, well thought out, and they're going to say that this is persuasive authority in other circuits and try to get those circuits to expand the definition of in custody to include sort of. I just can't imagine that you wouldn't. That would be the logical thing you would do.
Right. Okay. Wow. All right. Well, we're at like an hour and a half or hour and 40 minutes. So let's shut it down.
Well, I think we should. So how do we get in touch with our people who are out there listening by the thousands? How do they get in touch with us?
It almost seems like a chicken and the egg thing there. If they're already listening to us, then they know how to find us. But please tell all the people that you know, go to Google, DuckDuckGo, Bing, Ask Jeeves, I don't know, all of them, and type in Registry Matters, and you can find the website, which is registrymatters.co. That is where we live. That's where the podcast is produced and released and all that stuff. But you can also find it on iTunes, Google Play. I don't do it on Stitcher. Anyway, you can find it all those places. And your favorite thing is tell them about the phone number.
Yes, I would love to get more phone calls. Just keep them kind of short so we don't have to have people fall asleep. But leave a message, and that's 747-227-4477, and we will play it if it's coherent.
Yes, I think you should get equipment like Mongler does in chat, and he has incredible equipment and sounds very smooth and buttery. All right, what about an email? Send in some email messages?
That would be registrymatterscast@gmail.com.
Awesome. And then if people, the very generous ones, want to support us on Patreon, where do they go?
They go to their bank and find out how much they have in the account.
Oh my God, we're up to how much you have in your... Well, actually, that could... Hey, look, Americans generally have, what, $400 in savings? If they had a $400 car bill, they couldn't pay it. So that might not be the best approach.
So, no, you go to... What is it you go to? Patreon.com/registry
matters.
And you can find an option as little as $1. And it will...
$1 a month.
It will come out on the date you designate, and it will come in, and it will just be so flattering to see our number of patrons go up from 30s. We want to be over 100 by the end of the year.
Will that give you a gorbasm?
It would definitely. If we were over 100 patrons by the end of the year, it would give me a gorbasm, even if they were all $1.
Absolutely. Outstanding. And we have a bunch of people in chat tonight harassing me while we were recording this in a live stream. So if you want to go there, you can find a link in the show notes. But it's we have a Discord server if you want to hang out, and you can talk before and afterwards, possibly not during. But maybe you could ask a live question if you had something that was worthwhile. We might put you on live on the air and all that. And with that, Larry, I bid you.
There are dozens of people in here tonight.
Thank you for listening to the FYP
And with that,
Network.
Larry, I bid you adieu, and I hope you have a wonderful night, and watch out for those crazy legislators, because they're all scummy.
Thank you, and good night.
Bye, Larry.